Hello everyone! Today I will provide a high-level comparison between wills and trusts as it relates to estate planning. This is not a legal advice, and before making any legal, tax, or investment decisions, you have to consult with a qualified professional. There are a few common approaches to estate planning. Without a will or a trust, the government decides, based on the default provisions of the law, who will inherit your assets, who will oversee the distribution of your property, and who will handle your affairs when you're not able. This approach lacks estate and income tax planning, does not provide any asset protection, does not avoid probate, and results in a public process. Second approach. By having at least a will, you can do estate planning, even though income tax planning could be very limited. You can name the intended beneficiaries of your estate, name a will executor, and possibly foresee some limited asset protection aspects. However, through this approach, you cannot plan for your own incapacity. You will not avoid probate, and any asset distribution will become public record, which might expose the beneficiaries to creditor claims. The third approach, through a living trust, which by the way is the most common approach for a domestic trust, you can address all major estate planning needs, which are planning for estate and income taxes, naming the intended beneficiaries, trustees, trust protectors, naming someone who you trust to handle your affairs when you're not able, asset protection, probate avoidance, and a speedy and private distribution of the property and money. This is an illustration of how estate is being distributed through a will versus a living trust. There is a common misconception among clients that a will doesn't have to be probated. Well, guess what? Wills have to be submitted to a probate court, and probate proceedings are not only lengthy, but also could amount to thousands of dollars. In fact, in some cases, probate fees are calculated as a percentage of the total estate value, which could turn into an expensive process. On the other hand, when the estate is transferred through a living trust, typically no probate court's involvement is required, and as a result, the client completely avoids these lengthy and expensive probate proceedings. Also, through a trust, the client can plan for estate and income taxes, which is a huge benefit not only to the client, but also to his or her beneficiaries. So what's right for you? Doing nothing, having a will, or a trust, or maybe both a trust and a will? The answer depends on your circumstances, and I'm here to help.